Hello and welcome. I'm Judge Andrew Becroft and I'm the Principal Youth Court Judge for New Zealand. You know, 20 years ago there was a revolution in New Zealand. It was a legal revolution and it was a quiet revolution. And it almost came in unnoticed. And it was the introduction of the Children, Young Persons and Their Families Act 1989. What many regard as a world-leading, innovative, principled piece of legislation. And in part it dealt specifically with children and young people who break the law. Still 20 years on, it's important, challenging, deeply relevant piece of legislation. And it's how we deal with young offenders, how we approach them. The key principle in Section 4 is Section 4F. It's really a combination of the deed and the need. If you read it, as you will, it emphasises, number one, holding young people to account, encouraging them to accept responsibility. That's looking at the deed, the criminal offending. But the second part, the second prime responsibility, is to ensure that their needs are met, that which caused the offending. So it's the deed and it's the need. Start with Section 4, read those objectives, read Section 5 and then turn to Section 208. There are 9 key youth justice principles there. They will repay very careful reading. They're the foundation, they're the bedrock for all that we do in youth justice. So focus on these 9 key principles of the Act. And remember, they're a complex balancing process between the interest of the young person, the offender, their family, the victim and the public interest. This isn't a system where the welfare and best interest of the young person is the paramount and primary consideration. That's for the care and protection part of the Act. In the youth justice part of the Act, it's that complex balancing process. The Youth Court, you know, is a division of the District Court. And can I say this? It's not just a kiddies court, it's not a junior adult court, it's not some sort of cut down adult court. It's a qualitatively different specialist court. There are specialist judges, specialist youth advocates, specialist police, specialist social workers and specialist court staff. The youth court deals with 14, 15 and 16-year-olds and also the most serious 12 and 13-year-olds. It's about 4,200 young people coming before the youth court each year. Some of those are repeat offenders, so perhaps 6,500 young people a year. Quite a small group, quite a defined group. The main reason for that is that about 80% of youth offenders don't come to court at all. Good work by Police Youth Aid shuts down about 80% of youth offending with firm, prompt, community-based intervention. So in a sense, the youth court is reserved for that small group, the toughest, the most demanding, the most challenging young people. In some senses, depressingly, they show very similar characteristics. About 83% are male, few are engaged in education. Most come from severely disadvantaged, fractured homes. Many are alcohol and drug dependent. Most have a history of child, youth and family involvement, family abuse, family violence, and disproportionately too many are young Māori. That's the picture of those who we get before the youth court. Tough, challenging, demanding young people. They demand our best. You know, when I first got this job, I sat down in a large judicial common room for morning tea. And the first thing a senior judge seated next to me said to me was, "You know, Andrew, I can't understand what all the fuss is about. You've got your own office, your own support staff, your own resources. After all, when you think about it, the youth court is only 5% of the district court work overall." But then another judge, a senior judge, and I think a very wise judge, said, you know, 5% of today's work, 100% of tomorrow's work. What could be more challenging than that? The role of the youth court is to divert young offenders out of a life of crime, to build potential, to build functioning, responsible, socially beneficial adult lives. That's the challenge. Small part of the overall work today, 100% of tomorrow's work. So as we reflect on it, the youth court will deal with that most serious 20%. What's left after the police have tried good community-based diversion. They'll be either the most serious offences or the most serious offenders. As to most serious offences, offences like aggravated robbery, serious sexual offending, grievous bodily harm, arson. And it will also be those offenders, those repeat tough offenders, repeat burglars, repeat car conversions, repeat shoplifters. It's a small group. It's a very challenging group. What is it then that makes a youth court different? Two things. Firstly, a qualitatively different law, quite different from the adult court. And secondly, a qualitatively different process. Law and process. And let's start with the law. Perhaps I can give you some examples of some key provisions. The first couple of provisions to highlight are the duties on the judge and on the court to use both child, young person friendly language, and perhaps more importantly, to encourage a young person to participate. Quite unlike the adult court, where the defendant stands, as it were, mute and silent in the dock, in the youth court, the young person's encouraged to participate. Usually he or she will stand in the well of the court, and the judge has that duty to encourage participation, to encourage discussion. You'll usually see a youth court judge asking the young person to introduce themselves, to introduce their supporters and their family, and wherever possible to be talking. Youth advocates will be important, but the prime focus will be on the young person and getting them to participate. A second relevant provision is to keep young people separated from adults, and that's why we usually schedule a youth court on a different day from an adult court list day. And there's also an obligation on the registrar, on the court staff, to schedule youth court hearings to start at a time when the registrar best believes, best understands that there will be time to hear the case. In reality, that means an appointment system, and we run 10 or 15-minute appointment systems for young people. Another particularly important provision is that the youth court is closed to the public. Mind you, the media are allowed to attend as of right, and it's important that they be made welcome. There are good stories to tell about the youth court. We need to be transparent, and we need to ensure that those messages get out to the public. And another example is the restrictions on media reporting of the youth court. Leave is required for the media to publish anything about the youth court. Invariably it's given, but it's important to emphasise that under no circumstances can the name of the young person, their family, the victim and their school ever be published. There's no discretion here, it's just plain law, and it can never be done. Victims aren't able to attend the youth court as of right. Invariably, youth court judges would always give leave for victims to attend and take part in the process. What's different about the process? Well, for one thing, the setup of the court, and you can see it here. We like to have the court arranged in a U-shape or horseshoe arrangement. The reason for that is that it encourages participation, it encourages dialogue. We often have Child, Youth and Family Services sitting here. We have police youth aid here, often mental health services, representatives from education. And here we have the young person always standing, often with their family and with the youth advocate. That's the arrangement. It involves some chaos sometimes in reassembling the furniture, but it's a configuration that encourages participation, engagement and involvement of the young person, and that's a key principle of the youth court. So what else is different as to process? Well, for one thing, there's quite different terminology. Unlike the adult court, we don't talk about guilt or innocence. In the youth court, we talk about whether the charge is denied or not denied, admitted or proved. We keep a record, as we're entitled and required to do. There are different stamps even. And you can see here a quite different set and suite of stamps, all with their own youth court terminology. We try to develop continuity of judge, that is the same judge working with the young person and their family, and if the victim's in court, throughout the whole process. So continuity of judge is vital. Other examples of differences in process include the protocols. There are a number of them that the youth court has to ensure that young people are kept in police cell custody for as short a period as possible, that their remands and SIF's residence are constantly reviewed and again kept as short as possible, that the orders, the formal court orders that are handed to young people are done so promptly, preferably while they're still in court, in intelligible form. And remember in all of this that in a sense the youth court process is supporting the family group conference process. It's mandatory that every young person at some stage goes through that family group conference process. That takes place out of court, has no judge. In a sense, that's the engine room, the decision-making first cut as regards all the important issues that involves a young person. Those plans that are formulated at a conference are brought back to court. The youth court judge and the youth court approves them, perhaps modifies them. So in a sense, everything that the youth court does really is running parallel to and supportive of the family group conference process. And it's vitally important that all those involved in the youth court support that process, understand that process, and ensure that it is given effect. So the youth court, it's a combination of a different legal set of requirements, a different process. Different law, different process. Understand those differences, absorb them, put them into practice.